Okay, good. So, hello everyone. My name is Maria Musmuti. I am a lecturer at the Institute of Advanced Legal Studies. I would like to say hello to everyone. I will be facilitating this Urban Law Day. So, I would like us to start with the introduction and welcome addresses. And I would like to first give the floor to Dr. Remy Sitchping, Chief of Policy, Legislation and Governance section from UN Habitat, for his welcome address. Remy, you have the floor.
Thanks a lot, Maria. Good morning, good afternoon, good evening to everybody. On behalf of UN Habitat, I'm very pleased to welcome you all at this 7th edition of Urban Law Day, which we usually celebrate with the Institute of Advanced Legal Studies of the University of London. In this context of unusual time, this is the first virtual Urban Law Day that I'm happy to see many faces, many of you joining during this special celebration. This Urban Law Day is one of the fruitful initiatives we have had in terms of building the partnership between IALS and UN Habitat, and we try through this Urban Law Day to bring together a diverse range of urban law stakeholders to address urban challenges by exchanging information, sharing knowledge, sharing what we have been doing, trying to identify relevant skill sets, particularly in the area of policy making, governance, and legislation. That will hopefully will all contribute to promote and harness better sustainable and inclusive urbanization. I would like to appreciate that UN Habitat and the Institute of Advanced Legal Studies have begun this initiative, for those who are not aware, since 2014, based on the shared appreciation of the relevance and importance of law and the importance as well of its effective implementation, which could benefit many many people. So it's very important that we keep this in mind. In this context of COVID-19, it becomes more relevant to look at the contribution of laws and regulations in this uncertain time. This COVID-19 pandemic is showing that it's important to look at the type of regulations and the type of decisions that need to be strengthened. And one of the key elements that have come into play had been the coordination role, either assigned to national government or subnational government, the issue of rights and responsibilities of national, subnational government and the citizens, and how do we navigate through some of these rights and responsibility. In that context, it becomes very critical that regulation can actually try to level the playing field to benefit everyone and to address not only the recovery strategies, but the impact that it can have on many people around the world and in specific countries. At UN Habitat, we believe that laws have the power to regulate fair power relationship, to allocate equitable public goods and services, and shape urban institutions in a way that can promote human rights and inclusivity. We also value the participation and look forward to hearing more insight from the participants, all the presenters here gathered to really look at this particular topic of COVID-19 and in the context of cities, with the focus on lesson learned and what the future of law might look in after COVID-19, if this after COVID-19. At UN Habitat, just to close, we are particularly eager to contribute and learn from all the discussions and take away some key entry points, some key lessons that will help us advance and support those who we serve. So back to you, Maria, and thank you, and look forward to a fruitful discussion.
Thank you very much, Remy. So I would now like to Dr. Constance Stefanou, the director of the Sir William Dale Center for Legislative Studies of the Institute of Advanced Legal Study. So Kostas and Remy are the two, let's say, leaders of this partnership, and I would like to thank them both for their contribution. Well, Kostas, you have the floor.
I hope you can see me. I'm doing the responsible thing. As you can see, I'm wearing a face mask because this is a seminar on urban law and what to do in an urban environment. And according to the World Health Organization, we should wear a mask. So this is what I do. So I would like to welcome you all on behalf of the Institute of Advanced Legal Studies and the Sir William Dale Center for Legislative Studies for Urban Law Day 2020 with the topical title, The Post-COVID City, Lessons for the Future in Law and Development. It is our first ever digital conference, and although I know that people are already complaining that there are far too many webinars and some might even feel webinared out if there is such a thing, I am very glad that we are today able to have colleagues from Africa, from America, colleagues who might otherwise be unable to attend in person. This is our Urban Law Day number 7. And I'm very proud. I'm proud because in the UN Habitat and IALS relationship, Urban Law Day is the tip of the iceberg. And my colleague Maria Musmuti, I think, has prepared a presentation detailing the different facets of our relationship. Thank you for coming. Thank you for attending this digital conference, which is, of course, very topical. And just to remind people, the IALS has a whole day conference on emergency legislation and COVID-19 on the 10th of September. I will now leave you in the very capable digital hands of my colleague, Maria Musmuti, who I think has a presentation ready for you. Just remember that I will be happy to publish an article version of your presentation in the European Journal of Law Reform. And of course, if we have enough presentations to reach 55,000 words, we can even have a special issue on urban law and COVID. I will not go away, of course. I will merely silence my microphone and camera. Thank you very much. Thank you for attending. And I think, Maria, it's over to you now.
Thank you very much, Kostas, for this warm welcome. Like Kostas said, if it's possible to mute your microphone, you do not have the floor. And I would also like to let you know that the meeting is being recorded. So I have a very brief word to complement what Kostas and Remy already said. I have a very short PowerPoint just to show you what we've been doing during the last 6-7 years that we've been working together. So I will try to talk you through this very, very quickly before I move on to the presenters and to actually presenting the presenters and then giving them the floor. So as both Remy and Costa said, our partnership has been going on, started in 2013, 2014, and we consider this to be a good match, what you would call a good match. Why? Because we think that we are good in generating knowledge, and UN Habitat is very good at using knowledge to create impact. So it is this combination that we see as a driver for development, and we're very proud and very happy about that. So what we've done so far with the Sir William Dale Center for Legislative Studies and UN Habitat, we've organized 7 urban law days. We've organized 3 week-long capacity building seminars in which more than 60 experts from around the world and different continents participated. We had 1 short training in the Malaysia World Urban Forum where 120 participants were present and actively engaged in the discussions. We've contributed in different ways to policy discussions around in the Habitat 3 expert meetings, the World Urban Forum, etc. We've issued some thematic newsletters. On the latest ones are on smart cities and human rights cities. And we've tried to generate knowledge through academic papers, participation in conferences, contributing to collective volumes. We've also had some joint publications with the contribution of students. So we're trying to involve the new generation of learners also in this partnership. And I think this is very interesting. We've also contributed, again, using students to work in projects to 3 ongoing habitat projects. So we have this dedicated Urban Law Initiative webpage. So I will be uploading all of the content and the presentations if the presenters agree there. And all of these are active links. So if anyone is interested to find out more, you could do so by accessing this presentation and finding out through the links. So what do we think we have achieved? I would say that one of the things that I believe we have contributed to is that the role of the law and the importance of law for sustainable development is now more widely recognized. I mean, it was always back there in the back of everybody's head, but I think now it's more in the agenda, it's more in the discussion, and I think this is something I would like to hope that this is something that we have made a contribution to. I think we've tried to, and we've achieved to network, to assist in the networking and discussion between academics, policymakers, and practitioners. So trying to bridge academic knowledge with practice, trying to bring issues to the agenda and identify niche areas that then can be taken up in policy and legal discussion, then feeding into ongoing policy work and using academic knowledge to improve practice, as I said before, and then building awareness around legislation and lawmaking and the fact that specific skills are needed for this. So not everybody can do it, but getting more familiar with what is required. So all this brings us to this first online 2020 Urban Law Day on the post-COVID city. So the purpose of this and the thinking behind this Urban Law Day was to try to focus on the lessons. What did we learn from this pandemic? And if this were to happen again, what should or what could we do differently in relation to cities and development? So we have an amazing cohort of speakers who have agreed to be part of this Urban Law Day, and I would like to thank them all. I will be presenting them in a moment. We have an impressive attendance list. We had almost 200 registered participants until a couple of days ago. So I hope they will be able to join us. And we hope that we have a great forum for discussion. So please make sure you send your questions in the chat. And we will, from our side, we will try to make sure that we have sufficient time to address all of them, and if not all of them, as many of them as possible. So coming to our speakers, we have with us today Professor Marius Pieterse from the University of Witwatersrand in South Africa. Marius is a well-known scholar in constitutional and socio-economic rights, and he has been active in this field with very significant contributions. We have with us Professor Gita Tiwari. Excuse me if I'm mispronouncing. She's the director of the Urban Law Center at the Fordham University School of Law, and she's also one of the editors of a very important collective volume on law and the new urban agenda, a very important contribution to the discussions around urban legislation. We have with us today Robert Louis Lettleton. I guess we all know who Robert is. Who is Chief of Land, Housing and Shelter Section at UN Habitat. So Robert was was leading this when it all back when it all started, and I would like to thank him for all his contribution during the previous years. And we also have Dr. Anna Paula Pimentel-Walker, Assistant Professor of Urban and Regional Planning at the University of Michigan. We have very interesting contributions, and without taking any more time, I would like to give the floor to the first of our presenters, Professor Marius Pieterse, for his presentation that is titled "Rights Clashes, Legal Fault Lines and COVID-19 in South Africa's Informal Settlements." Marius, you have the floor. Please, everyone, mute your microphones, and if you have any comments or questions, please write them in the chat box. Marius, over to you.
Thanks, Maria. I'm just checking that everyone can hear me. Can you hear me?
Yes, we can hear you very well.
Okay, great, thanks. And I'm hoping that you can see the screen that I am sharing.
We can.
Thanks, Maria, and thanks for the opportunity to present. So as with other public health crises before this one, COVID-19 is highlighting society's fault lines, and I'd like to briefly reflect today on some of the legal fault lines in housing law and human rights law that I've come across recently in engaging both with government officials, representatives from civil society, and housing developers in trying to crystallize an appropriate policy response to the virus in South African cities and informal settlements. This exponential graph that you see is South Africa's from about a week ago. It shows the rise in total number of COVID infections in relation to major government responses, represented by the numbered arrows, with number 4 representing South Africa's early hard lockdown being imposed, mainly to buy time to capacitate the health system, and numbers 6 and 7 depicting the 2 main staged relaxations of this lockdown and the gradual reopening of the economy, which, as you can see, has also opened the gates for the virus. Throughout, much of the government focus, as well as media attention, has been on the impact of the virus and the economic impacts of the lockdown on the estimated 1.2 million vulnerable households in South Africa's estimated 2,700 urban informal settlements, where overcrowding and lack of water and sanitation services complicate both physical distancing and hand hygiene, where individual and collective health statuses are already compromised through poverty, and where access to healthcare services is frequently hampered. Clearly, human rights law and public health law both obliged government to target these settlements in its COVID response. The question was, and to some extent remains, how? Perhaps predictably, as elsewhere in the developing world, the knee-jerk government response has been a top-down intervention, partly involving a welcomed urgent rollout of water, sanitation, and hand-washing supply in communities that lacked access, but also partly involving a less welcomed commitment to the urgent de-densification of informal settlements and the relocation of some residents to temporary residential areas. Now, this was publicly justified and genuinely intended also by the Minister of Human Settlements, pictured on the slide here in her mask, as a measure aimed at advancing the right to health by reducing overcrowding and thereby vulnerability to disease. But it predictably raised the ire of housing rights advocates, with 14 civil society organizations swiftly releasing a joint statement expressing deep concern at the proposed measures, which it was feared would amount to eviction and removal of residents, thereby threatening livelihoods, networks, and access to amenities. And so, as elsewhere, it resulted in a fairly unhelpful standoff between the right to health and the right to housing, which has taken quite intense dialogue to resolve. Now, of course, crises are seldom as immediate as they seem. They tend to be constructed over many years by several forces, including policy and law. And the current public health crisis in informal settlements is no different. It is long-standing deficiencies in the content, implementation, and articulation between existing housing policies and laws that have both led informal settlements to pose the health hazard that they do, and have led government to have to resort to fresh disaster management regulations to try and bridge and supplement the shortcomings of existing policies and laws. I'm thinking here primarily of two progressive policies that were at the state's disposal at the outset of the outbreak, being the Emergency Housing Program, or EHP, and the Upgrading of Informal Settlements Program, or UISP, both of which pretty much do what it says on the tin, but neither quite catering for the kind of response that now seems to be required. Both the EHP and the UISP are devolved programs, rightly triggered and led by municipalities in accordance with their integrated development programs. But this has led to their uneven implementation due to uneven capacity and uneven political will at municipal level. And it has rendered crisis response contingent on municipal cooperation, which, for the same reasons, couldn't always be counted upon. The EHP, while certainly responsive to disasters, has quite a piecemeal and inconsistent implementation history, and has often led to the kind of consequences civil society organizations have been keen to avoid in scenarios like the current one. Often people have been relocated in terms of the EHP to far-flung temporary relocation camps, which have been no better serviced and far poorer connected to the urban fabric than the informal settlements that they were meant to temporarily replace. As often, relocation has not been temporary, with many communities still in relocation facilities many years after their initial relocation, which in terms of tenure, on the contrary, remains both temporary and precarious. Civil society organizations by far prefer the UISP, which is a participatory and in situ program aimed at gradually and incrementally formalizing informal settlements. Although this is a program that does not sit well with the political discomfort with informal settlements and with the government's preference for slum eradication and so-called rollover upgrading, where areas are developed with subsidized formal housing after inhabitants have been relocated. As a result, the UISP has never been well nested in the surrounding legal matrix. While spatial planning legislation allows for recognition of informal settlements and their integration into the surrounding urban fabric, the zoning and land use management bylaws of most municipalities do not optimally cater for in situ upgrading, which also goes against the logic of, for instance, engineering standards, building standards, environmental impact processes, and so on. And if you then add time-consuming land acquisition processes and difficulties with devising and implementing appropriate tenure options, as well as tardy and decapacitated municipalities, you then have a program that, while full of potential, is not capable of delivering at the tempo and scale that the response requires. And so the challenge has been devising a set of disaster response directives that articulate with the strengths of the EHP and the UISP while supplementing their weaknesses and advancing both the right to health and the right to housing, which, it needs to be pointed out, have themselves also not optimally developed in South African constitutional law and jurisprudence. In the main, I would argue this is because they've been developed separately in silos, in a piecemeal case-by-case manner. Litigation on the right of access to healthcare services in South Africa has been very care-centered, with all major court cases having relied on the right of access to care in Section 27 of the Constitution, and typically challenged laws that restrict or diminish access to medicine or hospital care. There's been almost no jurisprudential development of rights to environmental health and determinants of health, which ought to provide for better guidance for the balance of public health concerns against concerns associated not only with individual liberties, but also more collective rights, like the right to housing. This right to housing, meanwhile, has mostly been defensively invoked to stave off evictions, which has meant that, when successful, it has often served to defend the status quo, people living in circumstances that actively endanger their health and well-being. We have little clarity on the positive dimensions of the housing right, apart from emergency situation where, thanks to the well-known Grootboom decision of the Constitutional Court, there's a duty on the state not to turn a blind eye to the emergency needs of those most in peril. Elaboration on this obligation, perhaps along the lines that it was applied in the Kyalami Rich decision to justify the construction of an emergency camp near a well-to-do suburb, would have gone a long way in the current circumstances to imagine a policy response that at once removes people from immediate health threat, but not from their right to the city. Other features of South African human rights jurisprudence that is useful for the response in the current crisis is the Housing Rights' insistence on judicial oversight for eviction, even in terms of disaster management legislation. The well-developed proportionality analysis for deliberating limitations on individual rights, though this has unfortunately never been applied to balance tensions between seemingly conflicting socioeconomic rights. Similarly, underdeveloped links between the common law on informed consent for treatment and the right to health. And this one finally is well developed, the requirement developed in eviction jurisprudence that evictions must be preceded by meaningful engagement between communities at risk of eviction and the state over, among other things, the reasons for eviction, the alternative forms of accommodation to which they can avail themselves, and so on. Fortunately, as a good faith attempt by the government to bridge the health housing standoff over the COVID response, the state has resorted to a similar but higher level form of engagement. It established a policy platform with department officials, civil society organizations, local government, academics, social movement representatives, and others to try and thrash out the way forward for COVID and informal settlements. Through endless negotiation, reports, and bickering in weekly Zoom meetings, alongside an annoyingly active WhatsApp group and a Google group of information sharing, a compact was finally reached between government and civil society, in terms of which the initial de-densification drive has been significantly watered down, though not entirely extinguished, and it's been aligned more closely to the implementation of the EHP and the UISP. Since the beginning of the lockdown, there's been a strong and uncompromising prohibition on evictions, which, though getting municipalities to adhere to this ban has not been easy, with the minister now reportedly resorting to litigation after several instances of brutal evictions by the city of Cape Town. But the policy response over and above that has been to direct municipalities through Disaster Management Act directives to implement the EHP and the UISP. Quarantine and isolation of people who are ill with or exposed to COVID-19 is dealt with through a different set of regulations, through health regulations under the Disaster Management Act. Whereas for a number of vulnerable settlements, transitional residential areas have been constructed, but close by and on land earmarked for permanent housing. The department is then trying to establish through a process of deep community engagement, a process whereby people can self-identify whether their living conditions put them at risk of complications from COVID and apply to be moved to temporary residential areas, with preference then given to the most medically vulnerable people. It's too early to say whether this will work or will be sustained, but it's up and running, and at least it's a long way away from the blunt de-densification response that was initially feared. Of course, the far bigger challenge is to tie this response to a medium and a long-term program towards improving health and other conditions in informal settlements. But in this respect, it's at least encouraging that the COVID crisis has focused our attention on the legal and related shortcomings of the UISP's more sustainable and progressive implementation. Thank you.
Thank you very much, Marius, for this informative and insightful presentation. I would now like to please, anyone, if you have questions for Marius, we will be addressing all the questions at the end during the Q&A session. So please write your questions in the chat. If you want to address them to a specific speaker, please make sure you indicate which one. So thank you very much for this, and I would now like to invite Professor Geeta Tiwari to present on equal pay as a human right, a closer look at New York City human rights law after COVID-19. So human rights have been, gender issues have been very, very prominent in this crisis, but not probably have not been given too much attention when it comes to the design of measures or anything. This is just a personal observation. Gita, you have the floor.
Okay, thank you so much, Maria. And thank you so much to UN Habitat and the Policy, Legislation, and Governance section of the Urban Practices Division for the invitation to participate in this discussion today. I am grateful to work with UN Habitat on inclusive critical thinking and practices that are required, especially today, to affect change in our cities. Today, I will be discussing the beginning stages of my research on New York City's 2017 implemented salary history ban for job interviews and what this means in this time of crisis for New York City. I will begin with frankness for how this research developed, and then an overview of New York City's current situation in relation to the pandemic and the racial justice movement. Next, I will discuss the United States law and policy in relation to pay equity at the federal level, and then specifically at the New York City level, explaining specifically the purpose of New York City Human Rights Law number 67, which bans interview questions related to past salary. Okay. My research in this area began in my work with the faculty director of the Urban Law Center, Professor Nestor Davidson, on this book that Maria had mentioned, Law in the New Urban Agenda. And the law in the New Urban Agenda examines the legal dimensions of the NUA. And in working with our chapter contributors on issues including post-natural disasters, transportation and mobility, informal workers, issues that all severely affect marginalized communities. I wanted to focus on how the intersection of gender equity and cities, specifically in New York. So the most recent data shows that New York City accounts for approximately 22,000 of New York State's 31,000 deaths, and about 222,000 of the state's 400,000 confirmed cases of the virus. With the recognition of the color of COVID, African American and Hispanic communities are dying at about double the rate of white communities and are more likely to be frontline essential workers in this pandemic. Coupled with the virus's disproportionate burden placed on women as caretakers more often than men, especially in single-family households, we need to respond to this current economic and health crisis in a way that addresses all people's concerns. This slide is a tweet from the New York City Gender Equities Commission. The Black Lives Matter movement was created not only to recognize systematic injustices, but to dismantle them completely. The New York City Gender Equity Commission has promoted participation in the census by all marginalized groups, citing that money is better allocated for education, housing, transportation, and healthcare with this data. In relation to job loss, the coronavirus has hit women harder than men. Women made up approximately 49% of the overall workforce in the United States, but accounted for about 55% of job losses in April. This was largely because they lost the majority of jobs in industry sectors most affected by closures due to COVID-19, such as hotels and the food industry. Women of color were hurt significantly harder. For Black women, the unemployment rate increased from approximately 7% to about 16%. And for Latina women, it was from 4% to 20%. By comparison, the unemployment rate for white men went from approximately 3% to 12%. In June, according to the Bureau of Labor Statistics in the United States, the rate of unemployment has improved. For most Caucasian men, it's now at about 10%. And for the Black population, it's gone down 1 point to 15, and for the Hispanic population to 14. Within New York City, the unemployment rate overall it varies between 15 and 18% right now. While both women and men are suffering the economic fallout of the virus across the world, it is women already more likely to be in poverty than men, and already more likely to be earning a smaller paycheck with less savings, and more likely to be in precarious jobs, who are being disproportionately burdened by the pandemic. Specifically, unpaid labor, cooking, cleaning, caretaking, predominantly still falls on women throughout the world. The global average is that women participate in the unpaid labor about 3 times more than men, and in some countries it's up to 7 times more. And these figures are only going to unfortunately get worse in the next few years with the economic and health crisis. So how does the law apply to this situation? So the federal law, the Equal Pay Act of 1963, was a step in the right direction. Employers were prohibited from discriminating based on sex. They could base their decision on anything other than sex. New York City took this law a step further to be more progressive. To give some background on how the New York City human rights law was created, in 1943, a Committee on Unity had been created, as it was the mayor's plan at that time to make the city a place free of discrimination, where democracy is a living reality. In 1962, this group was renamed and became the Commission on Human Rights, and given enforcement powers, specifically the authority to receive and investigate complaints. In 1965, Local Law 97 was created, which is the human rights law of the City of New York. The Commission's jurisdiction expanded through successive amendments. In 1981, the amendment to protect people with mental disability, and then to protect people include coverage of sexual orientation, protections in employment on the basis of conviction of arrest record, marital status protection in employment, and public accommodations as well. In the early 2000s, amendments were placed to protect victims of domestic violence. And most recently in 2019, just before the racial justice movement, prohibiting the targeting of people based on their hair or hairstyle at work, school, or in public places will now be considered racial discrimination. The change in this law applies to anyone in New York City, but is aimed at remedying the disparate treatment of Black people. The guidelines specifically mention the right of New Yorkers to maintain their natural hair, treated or untreated hairstyles. In practice, the guidelines give legal recourse to individuals who have been harassed, threatened, punished, demoted, or fired because of the texture or style of their hair. The City Commission can levy penalties up to $250,000 on defendants that are found in violation of the guidelines, and there is no cap on damages. The Commission can also force internal policy changes and rehirings at the offending institutions. The New York City Human Rights Commission is charged with the enforcement of the human rights law. And this is under Title 8 of the Administrative Code in the city. The commission is divided into 2 major bureaus, the Law Enforcement and the Community Relations Bureau. The Law Enforcement Bureau is responsible for the intake, investigation, and prosecution of complaints alleging violations of the law. And the Community Relations Bureau provides public education about human rights laws and helps cultivate understanding and respect among the city's diverse communities. The New York City human rights law is one of the most comprehensive civil rights laws in the nation. It prohibits discrimination in employment, housing, public accommodations based on race, color, religion, creed, age, national origin, alienage, citizenship status, gender, including sexual harassment, gender identity, sexual orientation, disability, pregnancy, marital status, and partnership status. So New York City's salary history ban paved the way before New York State to provide the salary history ban, which prohibits employers from asking about salary history during the hiring process. This city law is an example of instances where cities lead and states follow. It is imperative for cities to hold their own legal binding authority to create and execute laws and policy for the benefit of their residents. This past week, New York State Governor Cuomo stated, upon the cities entering phase 3, I also remind local governments of their duty to enforce the standards that have made New York's reopening safe and successful. I believe that this is a reference to the New York City Human Rights Commission and the active involvement they've taken in ensuring that people understand their rights in relation to discrimination, especially now in relation to the coronavirus. And here is an image from the Commission's website about the salary history ban. Why is this law so important, especially today? Pay inequity continues to plague the United States. The virus will only exacerbate this issue. The most recent Census Bureau indicates that American women still earn an average of 80 cents for each dollar earned by men. And a recent article by scholar Orly Lobel on reversing information flows and the future of pay equity, published this past April, states that the goal to correct disparity lies in 3 ways. First, inducing more information about salaries, including protecting employees who exchange information. Second, reducing information that reflects existing biases by preventing employers from relying on or asking about salary histories of new hires. And 3, requiring broader explanatory information from employers about pay disparity. This New York City law applies to the second part of this approach of achieving pay equity, because removing information such as previous salary will prevent assumptions that facilitate the pay gap, which may only get wider as women need to take a break from the workforce in order to provide childcare or other forms of management of their household. And the New York City Commission on Human Rights as it's charged with enforcing the human rights law, may impose a civil penalty of up to $125,000 for unintentional violation and up to $250,000 for willful, wanton, or malicious act. An individual may also bring a civil lawsuit for violations of law. The challenge is finding ways to regulate and enforce this law, ensuring that people feel comfortable and safe to come forward. In addition to the Human Rights Commission, New York City has a Gender Equity Commission. Concerned that too many New Yorkers continue to face discrimination because of their gender, the Mayor de Blasio established this commission in June 2015 to address issues of inequity and discrimination facing girls, women, and transgender and gender nonconforming persons, regardless of ability, age, ethnicity, race, faith, gender expression, immigrant status, sexual orientation, and socioeconomic status. The Gender Equity Commission this past June hosted a public town hall for people to voice concerns in relation to the pandemic and the racial protests that we have been experiencing. A holistic and integrated approach to women's economic empowerment is essential, especially now employers should be reviewing their policies and hiring practices to be certain that questions regarding salary history are eliminated and that written policies fully conform to the expectations of the law. The Human Rights Commission, in response to the pandemic, has been providing a weekly virtual Know Your Rights workshop to New York City residents and workers, and has invited companies to collaborate on these workshops. Nala Balji, the senior gender advisor to the Secretary General of the United Nations, stated, "Our formal economy is only possible because it's subsidized by women's unpaid work. Women are more likely to take a break during their career, to have children, or take a lower paying position that offers a more flexible schedule because of these unpaid labor concerns. This should not explain the pay gap, and unconscious bias and discrimination are more likely to affect the pay gap, but they are difficult to measure. The gap also widens with career progression." In response to these issues, and in connection with the New Urban Agenda and the Sustainable Development Goals, New York City in July 2018 issued a Global Vision Urban Action Plan to adopt the UN's Sustainable Development Goals and the resolutions, noting that it is an ambitious goal for sustainable, resilient cities by 2030.
Excuse me, Gita, can you please in 2-3 minutes?
Oh, sure. Of course. Sorry about that.
Thank you.
I guess I'll conclude by lessons to think about. New York City has these wonderful, ideal, and progressive laws, but we have to think concretely about how, as a city, we can make sure that they are being enforced and that the people of the city are aware of the laws. Thank you so much.
Thank you very, very much for this, Gita. Apologies if I cut you short. So from socioeconomic inequalities and their impact on informal settlements and their response to the COVID that was behind Maria's presentation, now we moved on to gender and racial and ethnic origin inequalities and others related to similar features. So now we move on to Robert Bruce Lexington and post-COVID prospects for the right to adequate housing. So Robert, over to you.
Okay, can you hear and see, I guess is the question.
We can both see. If you want to make the screen, yeah, perfect.
I think that's the first time I've ever got this right in one of these meetings so far, so I'm quite impressed with my developing skill.
Perfect. You have 15 minutes, Robert.
All right, I will try and get to the point. I mean, first, thank you to you and Anne and to Costas and IALS and Remy for inviting me back. I thought that once I had defected from the legislation unit, I would be cast out into the void, but luckily you have found a way to squeeze me back in. My first slide, for those who aren't aware, is my longing for the return to the office and a normal life. Although, as you may notice, it looks far more attractive and there are no people in the office, so perhaps it is more aesthetically pleasing during the lockdown, but not necessarily as practical. So what I wanted to do was to look at the various established components of the right to adequate housing, and the work that Habitat has been currently doing with a wide group of partners on looking at what's going on around the world, and then beginning to look at what the longer term implications of some of these issues may be, obviously within the legal framework. So first, the right to adequate housing, as it's recognized by the Human Rights Council, consists of a number of elements, and these broadly split into two halves. One is typical to many human rights frameworks. One is the question of freedoms. So there are several elements here. protection against forced evictions, the kind of more commonly understood sense of privacy and the right to protection of the home, and then the freedom to be able to determine where you live. So looking at each of these in turn, if I can get it to go to the next, yeah, there we go. So particularly on forced evictions, the picture is a recent eviction from Nairobi. This kicked off in around March and is part of a series of evictions that have been going on and demolitions, which, believe it or not, this episode you're watching is protecting our collective public health. The reason is the justification is the extension of a water and sanitation project. It was planned from prior to COVID hitting, but the importance of carrying it through has been highlighted now. So I would say as Habitat overall, we don't believe that we've really witnessed a particular increase in evictions or relocations during the crisis. And we're also very positive to see that a lot of countries have introduced protections. Some of those are very firmly legally entrenched. As Marius mentioned, there's a pretty clear legal provision in South Africa, which provides a fairly blanket protection. It allows, as I understand it, Marius will correct me if I'm wrong, it allows a certain proportion of eviction process to go forward, but it doesn't allow for the actual orders to be implemented. So this leads to one of our concerns, which is what happens post-COVID. It's been recently highlighted in the US as well that a lot of processes are now backing up in the system. A number of orders that may have been issued but cannot be implemented. So there is some fear in a number of countries that we may suddenly see a rush of evictions come forward once the emergency restrictions are lifted. Similarly, we are also witnessing a number of cases where COVID is used as the justification for an eviction or relocation. I always find it quite curious that urban planning really had its origins in public health. The idea of various infectious diseases and the air quality and things like that led to a lot of the early 19th century, late 18th century initiatives in urban planning. But that kind of got forgotten a lot of the way along the way, and it's not that often that you will really see much in the planning laws referring to public health these days. But obviously with the current crisis, that's absolutely come back with a vengeance. And it's frequently quoted as a justification for de-densification, for complete removal and relocation of neighborhoods and all sorts of other interventions. So the shifting of what is a legitimate public purpose may have a significant impact on the volumes of evictions that we see going forward. Of course, some countries, the court system is quite used to testing what is the legitimacy of a public purpose. Not only is the stated public purpose reasonable, but also is that actually why the government is taking the action it is and why it's taking it now. But other countries, they're not quite so strong on that, and there may be some specific issues that we think will arise going forward. So we're quite worried that so far, not too bad on the eviction front, but definitely some significant risks to be worried about going forward. The right to be free from interference. The question for those, well, I mean, I suppose most people here will be familiar with the basic concepts of proportionality in whatever field it's applied to. Is what the government is proposing to do, is it reasonable the way they propose to go about it? Is that reasonable compared to the purpose that they're trying to achieve? The balance on this has shifted quite dramatically. Governments are now able to intervene at a much more dramatic level than they could 6 months ago. In many cases with perfectly good reasons. But what is the framework within that's occurring? And the question will be, can we bounce back to the pre-emergency situation afterwards, or are governments going to try to hang on to this increased scope of power and authority, which, as we know in all instances, whether it may be at national level or at local level, if you have problems with an accountability of your government and they get this kind of increase in arbitrary power, that can present a real challenge. We're also witnessing a number of issues in the blurring of civil and criminal jurisdictions, for want of a better term. Many things which traditionally used to be considered as civil issues, and that potentially you could be fined for or you could be warned for, are quite rapidly escalated now, and frequently can become criminal charges. This is particularly a concern in terms of both spatial and group discrimination. Spatially, there is almost no doubt that oceans of literature out there that underprivileged neighborhoods, without a doubt, suffer a greater burden of criminal action in terms of criminal police action, enforcement, searches, criminal charges. These tend to be focused on underprivileged areas. As far as we can tell at the moment, that trend continues, and this applies probably even more in developed countries than developing to a certain extent. Possibly this is something that feeds into some of the civil disturbances that have been seen in the US and other countries, but it's also a significant factor in a number of developing countries. Frequently, if you look at neighborhood lockdowns, those also tend to focus on underprivileged neighborhoods. So there is a significant risk of discrimination. And again, the question becomes, when does this get lifted? Is this a trend that is going to continue? And if it does tend to continue, what is the capacity of the legal system to check it and bring it back into line? Because clearly the ground has shifted dramatically. On the plus side, on the question of choosing where you get to live, we see in a lot of public discourse that there is a much greater recognition of the importance of housing, not simply as a question of four walls, and not also only to do with public health. We see it going on in, well, public health in terms of the pandemic dimension. Also, much more attention is being paid to housing as a question of mental health, housing as a question of economic security, social security of entire communities, these kinds of things. That is definitely a very positive trend that we hope will remain, and critically that we hope will be supported with budgets. There is a very significant trend in a number of countries to push to see housing as a market-dominated sector. In our view, this is not likely to end well, and we need to make sure that the proportional engagement of public authorities is maintained. So if we're going to have a greater emphasis, that needs to be accompanied by greater public resources, greater public attention. We do face challenges. Freedom of movement is being considerably curtailed in almost all countries. Again, this is a question of who does this affect? For example, in many cities, this affects people with cars far less than it affects people who rely on public transport. It tends to affect people who are in middle class, relatively low density neighborhoods, less than it affects people in higher density neighborhoods. There are a number of disparities that come out of this. That is creating immediate challenges now, because freedom of movement obviously has immediate social and economic consequences. Whether you can keep your job, if it still exists, whether you can relate to your community, whether you can relate to your family. There are a number of issues around that. There is clearly, as I think this illustrates, a very high risk of disproportional impact from what are otherwise perceived as neutral regulations. So fairly sort of classic constitutional analysis. We're finding that there is also a fairly big concern around the degree to which duty bearers recognize the burdens that they have. There are a lot of people in public authorities who will tend to take the view on some of these issues that it's not their problem. Somebody else should be dealing with it. And that creates challenges with intergovernmental relations. What should the national government be doing? What should the local government be doing? But also in a global environment of relatively scarce budgets, it puts particular pressure on local governments because they will say we're simply not capable of providing a lot of the services that are being focused on. For example, in the UK, a lot of the social care burden is seen to be a local government concern, and that has come front and centre in terms of public health recently at a time when local authorities don't have any spare resources at all. There is also a question of what are the implications going to be for urban planning and the access to housing issues, the availability of housing. There have been considerable debates around, oh my goodness, more people in one place is a problem for COVID, so therefore we need to de-densify. What Habitat has been keen to point out is that the principal challenge is not really one of density, it's one of overcrowding. And that might seem like semantics, but at a practical level, it really isn't. Because if we push towards de-densification across the board as an attempt to address overcrowding, we are likely to fail to address the overcrowding priority and are likely to create an awful lot of other unforeseen negative outcomes. So we need to be careful that the way in which we allow COVID responses to influence urban planning, particularly to come through in the regulatory level, where in most planning systems, Anne can probably speak more to this, but in most planning systems, we find a very high level of discretion with how the regulatory level is implemented or even designed. And in this kind of situation, do we face a lot of knee-jerk reactions because the primary legislation doesn't create adequate checks and balances to manage that? Then looking on the side of entitlements, so as opposed to the things that the government shouldn't stop you from doing, the things that the government ought to be actively providing or protecting. So a few of these again. Okay, so on the security of tenure, I would highlight definitely as a positive, we are witnessing that the increased level of immediate term protection for security of tenure is definitely a positive thing, particularly because the way that a lot of the eviction measures have been implemented is they don't discriminate against tenure type. So, you know, at a basic level, whether you are a tenant or an owner is not particularly faced as a challenge, but at a more sophisticated level, the type of tenancy, the type of occupancy you have is not generally held against you. So a general occupant can take as much advantage of an eviction protection as other types. That's not always the case, but it is in some cases. However, looking at some of the other negative dimensions, there are quite a lot of short-term risks, particularly for what one might describe as the now increasingly popular term of the precariat. Those who don't really have a regular job, particularly in poorer countries, a lot of the day or hourly labor group, those who have informal agreements for their accommodation. A lot of people don't have leasehold protections. They don't have any kind of formal structures around them. In many cases, their houses may not even actually exist on maps and plans. This is mostly because the livelihoods for a lot of these people have disappeared. And while there is some legitimate concern around the interests of landlords of saying, well, if people can't pay the rent, then they need to be moved on because otherwise the landlord will become bankrupt. There is a question of the public policy of where do you want the burden of COVID to fall in a society. Presumably, as much as possible, we want to be shifting the burden up the resilience scale. So as much as possible, avoid direct burden falling on those least able to cope with it. Unless we maintain some of the protections and we look at the long-term implications of rent holidays and eviction bans, we run a risk of the precariat being in the long term squeezed out dramatically, which will probably further marginalize them spatially, push them more out to the fringes of cities, further away from transport and economic opportunity. but also from basic services in health, sanitation, and other things.
Robert, sorry, can you please in a couple of minutes?
Yeah, shouldn't take me more than a couple. Longer term risks in the landlord-tenant structures, which are sort of largely touched on, but more also in addition, the question of long-term risks in land ownership patterns. The fact that a lot of people who are relatively small scale or marginal landholders and have debt associated with that may not be able to maintain that ownership and control, and therefore we may see increased consolidation and concentration of land ownership in urban areas, which tends to also be an excluding factor. On the positive side, greater recognition of public health and the role of housing, which may allow us to start looking at housing as less exclusively a financial and a property-based issue, and may create more space for the social dimension. I know how to switch this along. Restitution, this is more about IDPs and refugees who have moved on and are returning. We don't have very good information on this at the moment. We know that IDPs and refugees face disproportionate impact where they are now. Whether public health will negatively or positively impact their ability to return to where they came from, we just don't know at the moment. But it is possible that there may be some impacts there. Equal and non-discriminatory access to adequate housing. Clearly, there is a negative impact from the economic fallout. There is also a negative impact due to perceptions of public health risk. Those in poor neighborhoods, those from low-income categories, are generally perceived by society as a higher level of public health risk. They get discriminated against, they get excluded. Also a risk in that public policy has been very focused on quick responses. We need to deal with this pandemic now. That significantly increases the risk of disproportionate impact because there hasn't always been very good analysis of the policies we're putting in place. In strong governance systems, that's beginning to feed through now, and we're being able to look at what's happening. Where that kind of policy analysis is not available, it's not so clear. However, on the plus side, there is much more discussion now of quality of housing as a basic need. That you can't just say we're trying to get a minimum number of roofs over people's heads. It's got to go significantly beyond that. Participation is a concern because, as in the situation with most, again, emergency powers, quick responses, that means that you get more centralized decision making and you get more directed policy making coming from the top. The plus side being there is a lot more discussion about community resilience and community solutions, but we're not sure whether that will have real tangible impact going forward. So the overall outlook on this is somewhat negative, but there is a potential to turn that around. And then really, this is just the close, is to say that these aren't so much legal questions, although they do have legal consequences, but the characteristics of what is adequate housing become important. Some which I've mentioned already, the security of tenure, the affordability and accessibility and location issues, but also we still have to keep an eye on cultural adequacy. I think the helicopter's decided I have to end now as well. And the availability of services and materials and facilities in the area. All of these are things that are going to have legal implications, and particularly are going to have civil rights implications going forward. Thank you.
Thank you very much for this overview and for trying to highlight the lessons and the risks and achievements. So let's now move on to Dr. Anna Paula Pimenta-Walker, who will talk to us about access to justice after COVID-19, the limits of the administrative law model to enforce socioeconomic rights in Brazilian informal settlements. A reminder to everyone, please share your questions in the chat, and once we address this first round of questions, then we will have another one. But please make sure that you send your questions and you also name the presenter to which they are addressed, or to all of them. So Anna, you have the floor.
Thank you so much for inviting me. I am very glad to be here. am sharing with you today my research with my colleague Maria Arquero de Alarcón and in partnership with the Gaspar Garcia Center for Human Rights. So I'm dividing these presentations in 3 parts. The first part is based on my court case research with informal settlements in areas of environmental protection. The second part is based on a participatory action research on access to water and tenure security during COVID with several housing movements and universities in São Paulo, Brazil. And the last part is just my 2 cents on how to move forward on a model of access to justice that is different from the administrative law model of enforcing housing rights. So what called my attention to this problem was being in the field and reading the literature and hearing people complaining that they had been fined for an environmental crime. So working with informal dwellers, they would say, oh, I have a fine and I need to appear in court because we deforested this area to build our informal settlement. And then is when I started seeing a dual discourse on young informal settlements, deforesting the city, depleting the Atlantic forest in São Paulo, or polluting the waterways. Simultaneously, there was another discourse about consolidated informal settlements being walkable, dense, and mixed use, therefore very good for the environment. The idea that how these issues, the right to adequate housing and the right to environmental protection, played out in the courts. So we were researching basically the judicialization of this planning issue of the right to housing in informal settlements and environmental protection. So our idea of studying court cases and specializing court cases was to understand the location of conflict in the city according to enabling legislations for the right to housing, such as special zones special zones for the right to housing that secure tenure for favelas and young land occupations, versus areas of permanent preservation in the city to preserve water and water bodies and the forest. So is there a judicialization of the planning process? And how does the judiciary manage these disputes between the right to housing and the right to a health environment in São Paulo informal settlements? And what were the most prevalent issues of access to justice for the informal settlements that had been threatened by eviction through these lawsuits? So here is a map of the informal settlements in São Paulo. Data from June 24 demonstrates that there is a great overlap between the people that self-declare brown and black and those that live in informal settlements and death by COVID-19. So 3 districts with the most deaths are also the ones with the most informal settlements in the city. How did our research took place? We researched the Court of Appeals of São Paulo, all the cases between 2013 and 2016 that had informal settlements in areas of environmental protection. We, after consulting the Court of Appeals database, we got to an end of 36 cases, which we photocopy in their entirety and mapped to understand the consequences. So this number doesn't represent the number of conflicts because we couldn't have access to the first level, the first district courts, or the administrative court cases in these issues. But it gives an idea of what kind of cases go to the second level of appeals in the state of São Paulo. The actors on these lawsuits are the public prosecutor, who has a mandate to enforce collective and diffuse rights, and the Public Defender's Office, which was created in 2006 in São Paulo, and their mandate is to advocate for informal dwellers, for their right to housing since 2006. So here is a table of our most common defendants. City planners appear as defendants in almost half of the court cases, and they respond for civil action lawsuits in close to 70% of the cases. So either the public defender is suing for the right to housing, suing the city for the right to housing, or the public prosecutor is suing the city to protect the environment and to clear informal settlements out of areas of risk for geological mudslides and washouts. So the city doesn't act much as a plaintiff in these cases. Only in 19% of the cases they are the plaintiff, and usually they sue the developer for letting the area to be occupied, the environmentally protected area to be occupied, or they sue the illegal subdivider. In terms of access to justice, this data, basically there is full representation at the second level of appeals. Every informal settlement is represented. Nevertheless, because we have copies of the case since they started in the first instance, the first district, it takes 353 days for informal dwellers to acquire legal representation. And but the most problem is not legal representation per se, but the service of suits, to get to know that there is a lawsuit that involves their informal settlement. And 78% of these lawsuits request the eviction of informal dwellers, but only 19% of them ended evicted. And we, our analysis of these cases is that they don't get evicted because these areas don't have much value, land use value, because of their environmental designation. You cannot build large things. So these lawsuits fulfill very limited function. They just stall the planning process, and this is very severe now with COVID. Since there is a legal pending that prevents the city from fully upgrading these areas, they stay in this limbo for years. And I don't have time to go over today, but we analyzed what kind of zoning typologies are more prone to conflicts, and we realized that it's precisely the zones that should be providing security for informal settlements. The special zones for social interest are the ones that are where most litigation takes place. More than half of the litigation here taking place in those zones. As you can see, in a more mapping these cases has been very important for us, because mapping is not common in legal cases, and they just talk about a point. So it's very difficult for an informal dweller to know if he is inside that lawsuit or not. And actually mapping and using drones can help us understand if there is any remaining environmental value to be protected. And you can see that there is a diversity of green areas that compose these lawsuits. So in not all cases, there is an actual conflict between the environment and the occupation. So what are the rulings of these lawsuits? Well, most rulings, 70%, affirm the supremacy of the plan and deny the plaintiff's claims for environmental remediation or housing rights. And this supremacy of the plan is justified by the separation of powers and by budgetary constraints. So judges say we cannot force, as the judiciary, we cannot force the executive branch to do to interfere in their housing plans or in their environmental remediation plans. And usually there is, we talk about a right to a housing plan rather than a right to housing, and a right to an environmental plan rather than a right to environmental remediation and protection. So in the 30% of the cases where the city had to do something about the living conditions of informal dwellers, the plaintiff was able to prove a life-threatening situation, the imminent risk of mudslides and washouts, and also in one court case, it was a public health emergency, given the fact that the plaintiffs were able to demonstrate that the houses were on top of open sewage without any trash collection and with a pest issues of pest control that were very serious. So what does this bring us to now in times of COVID-19, especially for these places of limbo? We have been collaborating with informal settlements. For example, writing expert opinions about the right of stay put during COVID and not being evicted. The Office of the Public Defender unsuccessfully petitioned to the National Council for Justice to impose a moratorium on evictions for informal settlements during COVID. That was not successful. But yesterday, the UN Special Rapporteur for Adequate Housing condemned the evictions during the pandemic in Brazil, especially in the state of São Paulo, where we work. Another issue that we work on is we adapted some of our participatory action research to the COVID times, developing a survey on access to water. We started hearing about worsening conditions, more days without water services. It's hard if you don't have a legal connection to call for services to be fixed because you are not a payer of that service. So with the two housing movements, we got access to their lists of informal settlements connected to their networks. We reached out to them with a phone survey to better understand interrupted access to water in these communities. We are now supporting legal action that is underway with this research in order to enforce access to water, and also the municipality asked for some preliminary results from this research in order to provide a better service for the communities. So this work is with all these partners that you see listed here, and it's still ongoing and preliminary. And this is the situation we are facing. Most cases of difficulties accessing water, the municipality is placing sinks at key points in informal settlements for washing hands. But we are advocating for connections to the individual houses in the informal settlements. So, what would access to justice look like after COVID? So what we realized after this research on seeking rights for informal dwellers is that the administrative law model of enforcing socioeconomic rights is absolutely inadequate for the post-COVID city. We cannot have court rulings that order the municipality to place informal dwellers in public housing waiting lists as the only solution for the lack of adequate housing. So this public emergency must broaden the way administrators, lawmakers, and judges conceptualize and implement the right to life and human dignity in informal settlements. So we are hoping that if the courts are more reluctant to enforce the right to adequate housing, that they will see some basic issues of sewage, drainage, and water access as issues of the right to life that they seem to be more likely to enforce. Thank you.
Thank you very, very much, Ana Paula. It's very interesting to see how research from the ground seems to point in the direction that not only the needs are changing, but also that the conceptualization of different notions is changing. Very interesting finding. Okay, great. Thank you all very, very much for these extremely interesting presentations, looking at different issues, but very closely related, like the balance of rights and rights clashes, the role of proportionality, access to justice as a specific area, housing, and then gender as a cross-cutting issue. So I would now like to open the floor for questions. We have some questions in the chat that we will start with, and then we can move on to the ones that come later. So please continue to write your questions, any questions you have in the chat. And if we have time later on, you can, no, excuse me, before that, I want to very, very briefly give the floor for 2 or 3 minutes to Robert Home from Anglia Ruskin University for a very, very brief case study of how the City of London responded to the COVID. Please, Robert, try to be as brief as possible so that we have time for discussion. You have the floor.
Thank you. Can you hear me okay?
We can, yes.
Okay. I'm just going to make 3 points. And by introduction, I suggested that post-COVID London should have a window in this event because, of course, the Urban Law Day has always taken place in legal studies in London. And there's some quite interesting developments going on. I just want to say 3 things, basically. The first is the relationship between central and inner London and outer London. The polls of opinion say people don't want to go back to how it was before. They've got used to staying at home, not having to commute. They're afraid of going into crowded public transport. And the public transport is operating at half of what it was before. And they don't want to go into elevators and lifts that are like a breeding ground for the virus. So this is happening already. And what it has implications for real estate. One is that offices in the central area may be under-occupied and may be given up. It also means that if people are staying in the, let's call them suburbs, restaurants, shops, pubs will be more active there than they are in the central areas. So all of this is happening now, and post-COVID London will not be the same as it was before. That's the first point. The second point is that since we're talking about urban law, what are the likely legal changes? Prime Minister Boris Johnson in the last couple of days has proposed a further relaxation of planning rules to make it easier for landowners and developers to change uses and convert buildings into housing. So that the idea is that it's going to be easier to turn offices into housing. It was already like that, but it's going to be even more easy. Vacant buildings can be turned into housing. So this is potentially a further relaxation of planning controls. And of course, local authorities are so starved of cash anyway that they can barely carry out these regulatory functions. And the third point is really about resilience and the importance of public health measures and schooling. that there's a rethinking of what are key workers. And the key workers, of course, are the people who distribute the food, who collect the waste, and who make sure that schools and health facilities can operate. These are not people who can just stay at home in the suburbs and work remotely. So there needs to be a rethinking, and there is a pressure to restructure government, because we've had central government trying to do it all, doing it rather badly in the response to COVID, whereas local authorities and local health authorities have been struggling to cope. And the essence of the situation at the moment is that PPE, personal protective equipment, is being sourced locally when it should be really a central government function as part of public health resilience. And at the same time, the provision of certain things can't be easily done at central level. So there's a push, which also spills over into the provision of social housing, a push to get local powers back. Whether this will translate into legislation with our present government, I'm not sure, but there's a lot of very active debate going on remotely at the moment. Those are my 3 points: real estate change, planning change, and governance change, which feeds into several of your previous presentations. That's my main contribution. Thank you very much.
That indeed complemented what has already been discussed. So I would like to start with the questions now, and I will take them from the start in order not to lose track. So we have a couple of questions for Marius with regard to the intergovernmental tension between KZN and the central government, whether that is because KZN is particularly vulnerable to opportunistic land invasions, or whether it's something else, and whether the central government has to litigate is an example of how the law in action or of a failure. And then a second question that relates to the underdeveloped jurisprudential development in relation to environmental rights, and whether this includes the constitutional provisions and those of some of the early post-apartheid legislation, like the National Environment Management Act, or whether there have been recent test cases in relation to gaps and overlaps among the many laws relating to today's topics. So Marius, if you would like to take the floor.
Thanks, Maria. There has been different kinds of intergovernmental tensions between KZN and the national government. The litigation that's being threatened is not in relation to KZN, it's in relation to the city of Cape Town not adhering to the national prohibition on evictions. The city has kept evicting people and demolishing homes even after the minister flew down to negotiate with the mayor. It's the first time we have a case of a national government trying to get a city to toe the line in relation to human rights standards. So from an academic perspective, I'm very excited, though I suppose politically it's a disaster. But in KZN, from the beginning, municipalities have been quite unhappy with the top-down imposition of the whole de-densification initiative as it unrolled initially. And my sense was, although I'm speculating here, that the KZN government was at the time negotiating tensions between the Durban municipality and the social movement called the Abahlali in Jondolo in relation to evictions that were carrying on. And they had just managed to negotiate a truce in terms of which there wouldn't be any further evictions or relocations when the national directive came through that there was going to be relocations. And so KZN had to defy the national directive and issue a press statement that they wouldn't be relocating because they didn't want to be seen to be going back on their promises. So it's all been very behind the scenes politics. In relation to David's questions, yes, very much. We haven't really had any real jurisprudential elaboration on the content of the environmental right in the Constitution or the substantive principles in NEMA. NEMA litigation has been very administrative law focused, if I can accuse it of doing that, whereas constitutional law-wise, the only real elaborations on the Section 24 right that we've had has been the Kyalami Ridge decision that rich people's environmental rights have to yield to the emergency needs of poor people, which is welcome. And then a little bit of acknowledgement of intergenerational equity as a principle in sustainability. But not really any elaboration on what the right to a healthy environment or an environment conducive to health and well-being means, what the obligation on the state to protect the environment means. I mean, NEMA is a good statutory elaboration, but in human rights law, that balance seems to me to be missing. The last question also from David was, have there been any test cases in relation to gaps in the overlaps between the policies that I spoke of? Not in relation to those gaps, no, but what we have had are cases that have triggered the upgrade of informal settlements programs. So cases where, due to the gaps that I was highlighting, municipalities were not implementing the UISP. There's been two decisions, one the Nokotiana case, where the court ordered the provincial government to take a decision that would enable the municipality to implement the UISP when it was stalling. And then another, the Milani case, where the city of Johannesburg wanted to go ahead with a rollover upgrade, but relying on the right to housing, it the court ordered that the city has to look into implementation of the UISP instead. So we've had those, but not in relation to the substantive gaps. Thank you.
Thank you very much, Marius. We have a question from Peter, actually comes from me. And my question is, how do you think that gender can be taken into account, gender and racial and other features can be taken into account when formulating responses to the pandemic or similar emergency situations in the future at city level? I know it's a very general question, but I would appreciate your reaction to that. Peter? Sorry, my screen is freezing. Hello?
Oh, sorry about that. So I was reading in the newspaper yesterday about a lawsuit that a woman filed against her former employer in California. She was fired in June, and essentially her supervisor had several complaints that there was noise in the background of children. Several meetings, young children, came onto her lap, and obviously it's an allegation. I don't know the circumstances, but in reading that, I was struck by the necessity for public-private community partnership to respond to times of crisis. And I first learned about this model of urban innovation from Christian Iaione and Elena De Nicolas, who wrote about this in the book that I talked about earlier. And I think that, it's a partnership at an individual level. The men that are especially supporting women and are understanding of these issues that we are all facing as a community, that we are all trying to work through together. But I also think, aside from the individual and community level, it's a public-private partnership. So coming together with governmental agencies and employers and companies to form plans for what we do in the time of a crisis, who are going to be the designated childcare providers for essential workers. How are we going to map out a plan for people to get their work done when they have to get their work done remotely as well. What is the protocol and understanding, and how do we enforce it so that people have safety in their employment and in their homes as well. So those are some ideas I have to take gender into account in times of crisis.
Thank you very much.
Thanks.
So we have a question for Robert. To what extent are local municipal authorities you are familiar with using SDG 11 in policy making regarding housing? And there's one from Gita to Robert and Marius. I'm struck by the issue of freedom of movement and the intersection between the right to safe housing, fair pay, and domestic violence. And how can this effectively assist with housing safety for these victims, given that in this pandemic, movement is so challenging indeed? So Robert first, and then Robert and Marius, if you want to respond to these, please take the floor.
Sure. Thanks. Not simple questions, most of these, but on the local authorities one and SDG 11, I think the answer is basically yes, there is evidence and there is some momentum around this, mostly the voluntary local review process. I think New York is a big champion of that as well. It's being discussed at the high-level political forum on the SDGs this week, so there's quite a lot of activity around that, and I think it is because the voluntary local reviews, as in any kind of monitoring exercise, they tend to trigger policy behaviour and drag it behind them. It does increase the responsiveness to SDG 11. On the freedom of movement and domestic violence question, this is definitely a concern. I mean, I've seen conflicting reports around the volume of domestic violence, but certainly in the cases that are occurring, lockdown and everything else exacerbates the circumstances. It's not an area of my expertise, but it's clearly right up front a multi-layered issue. You start with the basic question of protections. So some elements of exemptions on quarantine and lockdown restrictions. You need more emphasis on local provision of protected shelters and these kinds of things. But then I think there are a number of layers that go well beyond that will have to be linked into social policy, and also the question of welfare. It's not just a question of housing, but also food, income, children, those kinds of things. So how do you relocate? But at the basic level, there is a real risk in a number of countries where women who are, particularly women, I know it's not exclusively, but particularly women who are facing abuse in the home have been struggling a lot with being picked out by security forces for breaking lockdown. Where possible, that obviously needs to be clamped on, but it's an issue.
Marius?
Yes, Gita, the domestic violence issue was raised near immediately after the lockdown was announced in South Africa, and indeed we then had high-profile increases in domestic violence, to the point where the president on a national television address highlighted the gender-based violence issue and condemned this. Right at the beginning, as the issue was raised, a national exception was then announced on movement restrictions to allow people who are seeking to escape domestic violence not to have to adhere to the lockdown restrictions, or to not have to adhere to movement restrictions. And then I only saw reports of Johannesburg and Durban, but at least both of those loudly and communicated their intent to address the issue and to both extend the number of shelters and extend the opening hours of shelters. I haven't seen any follow-up on how that's gone in practice, though.
Thank you. I think it's been a challenge worldwide. So yeah, really something we need to think about. We have a question for all speakers, but I would like you to ask you to keep this one for the end as your closing statements. And the question is the following: what do you think has been the main innovation in urban law that has led to the COVID-19 and that will transform the legal frameworks of the countries? So it's sort of the lesson stock-taking question. And I would like to ask you to come to this question at the end before we close. So we have another one from Gita to, no, sorry, I just read this one. One for Robert. In Brazil, there is an inversion of the centralizing tendency on public policies to deal with COVID-19. There is a hyper-affirmation of municipalities' autonomy and individual liberty to justify a big void of regional and federal action. A particular situation in the global context, how to deal with that and recover the regional dimension on urban planning in questions like water and sanitation policies. And we have another one for Robert. In order to build cities resilient to health crisis and considering that inadequate housing has been a hotbed of COVID-19, do you think that the right to adequate housing could become a duty for public authorities and a right of other citizens, at least neighbors? Robert.
Okay, yeah, continuing with the easy ones. I think I would, at the risk of being controversial on the hyper decentralization situation in Brazil, I mean, I don't think Brazil is alone. I mean, obviously, every country, these things take a slightly different trend. But I think there are a few other countries where this has also occurred. I mean, certainly, I think it's a feature of the US in many ways. Overall, to be honest, I mean, I can see the concern about the implications for regional approaches. But overall, I think it's a positive thing. I think municipalities, even when they do manage to accumulate much more authority and room for maneuver, as in the current situation, they're still faced with having to be very responsive to their citizens at the level of practical need. They have to look at the provision of water, power, street cleaning, whatever it may be. So the incentives around cooperation and integration, I think, are likely to be stronger on municipalities than they are on national governments. So I think that, combined with the fact that cities in and of their own right, even megalopolises, are unlikely to ever achieve complete outright legal and political dominance, it means that them being stronger is going to fit it better into a system of checks and balances and is likely in the long run to lead to better outcomes, whether that be at a national or regional or a local level. I think it might take a bit of time to settle, but I think that will come. On the question of adequate housing, I think my first response would be it's not going to become a duty for public authorities, because technically speaking, it already is. The extent to which they're really able to act on it and focus on it, I think, is shifting, because I think it's beginning to be seen not only as an issue of those who are concerned for those who are vulnerable, but it's beginning to be seen as a concern for everybody at the city and the society at large, which hopefully means we can crack the biggest problem, which is really whether we are going to raise and allocate resources to it. Most of the cities that don't spend very much money on social housing don't raise very much money in tax, and usually that means who aren't they taxing? They're not taxing the better off people in the city. So it is a catalytic issue for a number of other questions in the city. I hope that will move forward, but you know, politics can be a tricky thing, and humans tend to forget a crisis very quickly. Hopefully we won't forget this one as quickly as we forget some others. Over.
Apparently, this is a very transformative crisis. We have another question coming from the Philippines, and again addressed to you, Robert. And the question is, what measures should the public sector or the central government explore or prioritize to meet adequate housing needs post-COVID-19? And a little bit of context that in the Philippines, national government has pushed for de-densification in urban metropolitan cities to prevent overcrowding. The checks and balances do need to be in place. So I don't know if you have a response for that.
Well, it's a really big question, but I'll sort of skip to a couple of basic points. I mean, I think one, hopefully this can push for better quality policy and law, which focuses on the kind of outcomes we want much more directly, not so much process oriented, but really looking at what are our goals. For example, we find in many countries that you will sit with a provision that you must have 15 or 20% social housing in a new development in a country that might have 50 or 60% need for social housing. So clearly you've got a fundamental policy problem there, because you're not aiming to provide as much as is needed. If your starting position is failing, then where are you going to end up? So I think the current crisis pushes that into a new debate a lot more. For example, if we're talking about that specific question, and I'll end it here, but we could have a whole other meeting on this, I would stress. But looking at the question of de-densification in Philippines, de-densifying for who and with what outcome? Because if you're just de-densifying because you want to make middle-class neighbors of a low-income neighborhood feel better, you're not actually, that's not helping anybody. You need to help who are the residents that you are de-densifying, which means where do they end up? What are their outcomes? What are their guarantees? And historically, governments are very, very poor at living up to those. International law says they must provide those guarantees. It's very clear, but most of them don't live up to that. Hopefully this crisis will provide us an opportunity. We've shown, well, I'll leave the other comment actually for your last closing one you'd said. So I'll leave it there. Oh.
Thank you. So yes, I would like to go to that and start to reverse the order of the speakers. So I'd like to ask Anna first. I remind you that the question is, what do you think has been the main innovation in urban law that has led to COVID-19 and that will transform the legal frameworks of countries? And Anna, if you want, we also have a question, someone requesting your position on the Brazilian question. So if you want to say a few words, but please, we do not have a lot of time, so please try to be brief and talk. Thank you.
Yes, so what we see at the federal, so housing and adequate housing in Brazil is a shared competence between the municipality, states, and federal government. So they all have a shared constitutional obligation to provide housing. But as we know from times when now the federal government is withdrawing from that responsibility and ending all housing programs, then we have municipalities stepping up to fulfill that function that should be shared competence. So through different political times, we have a different balance in intergovernmentality when it comes to informal settlement upgrades and housing. What we see at the federal level right now is surreal, because the executive power, the executive branch denies the impact of COVID and is skeptical about implementing laws. So yes, 2 days ago, the president vetoed access to water and healthcare in indigenous territories in Brazil. And as a response to that, the Supreme Court is trying to remediate that situation. So what we have now is, regardless of political positioning, those that believe in the impacts of COVID in Parliament, in Congress, and in the Supreme Court, trying to counterbalance the lack of policies at the federal level. And then, as we see here in the United States, we have states at odds, several states at odds, had several state governments at the odds with their federal government on how to approach responses to COVID and post-COVID. So I hope that answered that question. In terms of how do I see urban law from now on, I think that what this crisis showed, even at the municipal level in São Paulo, is that over time there is a decrease in the capacity of even municipal governments to reach its population. So whatever the policy is in access to water or access to emergency food and protective equipment, there needs to be a partnership with organized civil society, because there are no mechanisms in place for the government to reach its populations. And in my work here in the United States with refugee-run organizations, I noticed the same thing. The county health departments have a very difficult time to translate information and to reach out to resettled refugees in the United States. And what we see in informal settlements, unfortunately, after so many years of progressive land use policy, well-established land use policy, we still see a lack in the implementation. So I think that even though Brazil has been considered a country for participatory planning, there still needs much more to be done in the respect of strengthening local governments and their relationship with organized civil society to better serve indigenous communities and to better serve those in the informal settlements.
Thank you very much, Anna. Robert, your closing.
Well, my two quick ones would be, well, first, I think the biggest and perhaps most surprising innovation for me has been how widespread the bans on evictions have been, particularly when we were told for so long before that it wasn't possible to intervene in systems and processes like this. Between that and some of the action on homelessness in some countries, suddenly the impossible has become possible. I don't feel, however, that that's likely to have the longest term impact. What I'm hoping for long-term impact will be shifting the public and the political perception of the right to adequate housing to really what was always intended, which is a more socially oriented right rather than a more property and market-based right. Because I think if we can get back to thinking about towns and cities and housing from the point of view of public health, from social welfare, from economic inclusion, then I think we get closer to what SDG 11 is all about. Over.
Thank you. Gita?
Yes, I think that, what has led us to the current crisis is really this friction between national, state, and local government and this attempted prohibition against urban innovation. And I see in the next 5 to 10 years that, with the struggle, local authorities and local governance will work towards new ways to help city residents. I was really struck by a Texas governor who said in supporting the economy and this friction between staying home and wearing masks or opening the economy and letting people out, that he as a grandfather is willing to die to save the economy for his grandchildren, meaning that let's open all of the businesses. And I think that cities are going to take the step forward to be more practical in the long term about responsible approaches to care for residents, young and elderly, in different populations. So.
Thank you, Gita. Marius?
Thanks, Maria. I think the most positive feature that we've seen and the most innovative has been the innovative use of participatory platforms and structures in South Africa. Whereas I think the greatest need that we've seen is the need for better functional channels and platforms for intergovernmental relations and cooperative government. The crisis has generally highlighted the elements that haven't been working in the legal system and has lent them a level of political urgency that I think is certainly useful. And we are seeing energy towards looking at, for example, what the legal hurdles have always been in the way of better implementation of upgrading of informal settlement programs. And there's actually now some political will to address them. And so that is the moment that we need to seize. Thank you.
Thank you very much. Very, very interesting. I find this stock taking extremely enriching. So I would now like to invite Shipra Narayansuri, who is Chief of Urban Practices Branch of the Global Solutions Division at UN Habitat, to say a few concluding remarks. Shipra, you have the floor.
Thank you, Maria. I've been quietly listening. Very, very, very interesting discussion, and thank you for having me with you today. It's been it's been very enlightening, and thank you all for having this very frank and open exchange around some of the critical issues that we're facing today. I think for me, I noticed you were talking about, what has been the innovation and what is the stock take and what are the challenges. For me, I think I was saying to someone today, what COVID-19 has done is it has sent such a strong message around, the issues of deep-rooted racial inequalities in cities and human settlements, structural fragilities of our societies that we could never do as effectively over the last several years. It has really brought into very sharp focus. It has shown us that those who are vulnerable because our policy making has not worked, our planning has not worked, our legal system has not worked for those people. And they will continue to be, and they are even more vulnerable due to this crisis. And they're caught in this vicious cycle. And the only way we can break that vicious cycle is by what was just being said by the demonstration of political commitment, the working towards impact and not just process, as Robert just said and has been saying in our shop for many years, and by working together. And the other thing that COVID has shown us in the places which have overcome or are in the process of overcoming the crisis or recovering from it is the importance of multi-level governance, the importance of collaboration, the importance of multi-stakeholder engagement, and the importance of multi-sectoral action. It is not something, it has shown us that one thing in one corner of the world can impact us all, will impact us all, much more than even the climate discourse managed to bring people around. So I think that's to me has been one of the biggest revelations of this crisis. I think it's also shown us as I was just saying, the importance of better policy, better planning, and better legislation. Cities and countries that have actually managed to cope with the crisis have had a combination of these and have been focused on looking at the impact of these planning, policy, and legislation. And I will always use these in the same breath because I think they go together. But the importance of these three dimensions of governance really working for those being left behind, that impact orientation that Robert was talking about. The crisis has also shown us that change is possible. That all the things that we talked about, that if there is political will and if there is partnership and if there is commitment and if there is just an understanding that all of this impact, what happens in the slums of Mumbai doesn't stay within the slums of Mumbai. It impacts the whole city of Mumbai, and similarly Nairobi, and similarly Sao Paulo, and similarly everywhere else. So I think, again, as was being said, the impossible has suddenly come into the realm of the possible. So these are all good things. However, I think we have to guard against the possible backsliding of progress made, whether on SDGs or on the Paris Agreement or on human rights. There are some very dangerous discourses out there, and I think we have to be very cautious about those. I was hearing some of the discussions around densification and de-densification. There is a very dangerous pushback against density, which says, everybody should be living in those sort of sprawling single family homes somewhere because density is not good for you and leads to spread of pandemics. No, actually, it's about overcrowding. It's about adequate housing. It's about not having basic services. Similarly, the pushback against public transport, the pushback against public space, and most importantly, the pushback against our human rights. That everything goes, that we have to control the pandemic so we can trample upon rights, we can trample upon basic rights of people because we have to control this crisis. I think we have to really, as a community, we have to really jealously, strongly guard against those. And I would really urge particularly this group and this community on, around urban law to be very, very mindful and very conscious and very careful about what is going on around us. For me, collaboration, partnerships for us at UN Habitat, but for me also for many years, partnerships have really been a critical cornerstone of the implementation of the SDGs and the New Urban Agenda, because none of us can do it alone. And I think that remains also very, very valid in the post-COVID recovery phase. And I think that's really my hope for the future. It is also, COVID has also brought a lot of engagement, a lot of innovation, a lot of peer-to-peer learning around a whole range of issues together. These virtual platforms have, in some ways, I have mixed feelings about them. They depersonalize the interaction a little bit, but they also allow us to reach hundreds of people in all different parts of the world in a way that we would have never reached in an urban law day celebration, in one city or in one university in the past. So I think we need to capitalize on these opportunities. And that's and keep this going, keep this new way of working while still looking at innovation all the time. We are very, very privileged as UN Habitat to have the Institute of Advanced Legal Studies, the Fordham Law Center, University of Wits, and all of you others as our partners. We recognize that many of you in academia are uniquely placed to facilitate these discussions and the discussion and to influence the discourse around urbanization. And I hope you will use your positions and your opportunities and your groups and your networks to do so. I hope that you will use these networks to promote the realization of the SDGs and to promote multi-stakeholder engagement and to bring everybody on board, because this is really only 10 years left to implement the SDGs. It's only 10 years. The SG calls it the decade of action. Really, it has to be the decade of accelerated, frantic action if we are to get anywhere in achieving these. So we will continue to nurture this partnership with you. Particularly a big thanks to you, Maria, and to Professor Costa Stefano for making this session a success, but more importantly for your long-standing partnership with us at UN Habitat, and to everyone who participated in the session today. Despite all these difficult times that we're living in, each one of us is on these sessions maybe 28 hours a day. In addition to everything else that we manage. But thank you for your commitment. Thank you for your resilience. Thank you for your engagement with us. And I really treat this as a moment of optimism and a moment of looking forward to everything that we can do together. Of course, my team would kill me if I did not acknowledge their efforts. So thank you, Remy and Anne and Robert, for the great work that you're doing. And together we can overcome a lot, and I think we can do this too. So thank you again.
Thank you very much, Shipra, for your words, but also for joining us. And I'm happy that this time it was possible virtually. I would also like to thank Anne for her work and for the work that we've been jointly doing for all these years, and all the other UN Habitat colleagues. I would like to thank Leon for facilitating this WebEx platform. I would like to thank Dali from our side for helping out with all of these, with the organizational side of things. And I would like to thank all of our speakers for their contributions, very, very valuable and very, very much to the point. And we were really honored and very, very happy to have you here. I don't know if Kostas wants to say a final word from our side. We're just 11 minutes over time, which is a world record for me. So
yeah. But very quickly, of course, my usual thanks to all of you who've made this possible. I just want to point out that in an urban law conference, we have 47 people at the end. So this is, if you like, the beauty of doing things online. Maybe in the future we should have a combination of the two, have it in London, but at the same time have simultaneous transmission.
Yeah.
This might also be a good idea. So thank you very much. Thank you to all of you. I will probably use the wonderful things you said on the 10th of September when we have our big COVID-19 and emergency law conference. So if you want to participate, by all means. By then, I hope we will have the full Zoom license, apparently, where we can have up to 500 people. Anyway, thank you very much. Congratulations to Habitat. Congratulations to us too. Maria, thank you very much. Wonderful. And I'm delighted to see that we have 50 people at the end. Brilliant. Thank you very much.
Okay. Bye-bye. Have a nice weekend, everyone.
Bye.
And hope to see you before next year's Urban Law Day.